This is the assignment. I have filed 2 memos before the DRPL. It has not distributed. The assignment is this. I have filed memo before the DR.
For modification or recall of the order, the group of cases that were charge employee, my matter was for regulation. It was tagged to that. When would have directed me here. There is a.
May I please, Your Lordship, that
This similar matter in Vartas employees suspend matter Lord. The state has filed it as appeal not in order. So already disposed of number of cases. Similar order I have already given. That must be
may I please, Your Lordship, that list is normally two time memo is given, my lord, but not listed, my lord. It is 2 time, my lord.
It will come. My lord, to notice admission matter, my lord, 2018.
Which year?
2018, my lord.
18 matter.
My lord.
In the next week you posting.
Pardon to make a mention. Pardon to mention, my lords, in this case, my lord, the auction is set to happen on 6, my lords. My lords, if Lordship may remember, auction of the mortgage property, my lord. If Lordship may remember, it's the auction of the mortgage property is of the husband, my lord. The wife has a residence order and attachment proceeding is pending. My lords have taken and
next week.
My lords,
Monday.
Yes,
Monday.
my lords, it can be 5th, my lords, because
5th.
my lords.
5th.
My lord.
Is holiday.
The respondent filed highly written application without making a party. After the order of the Honorable Single Judge, without hearing to me, set aside my appointment.
You are not a party.
I am not a party.
Got it. Next week?
Yes, well, permit you Thursday.
Thursday. Okay. Why you came so much running? You could have mentioned memo even in the middle if there is urgency. Yes.
Item 1.
Yes, madam.
The state appeal, Your Lordship, there's a delay of 711
What is
days.
the explanation offered for that? Let us read.
Your Lordship, this is a regularization matter. And
How many years of service?
they were initially engaged as contingent classes from the year 1995 to 1990. Then as 90. And then as per the 1997 circular of the Finance Department, 15/5/1997, they were all regularized, Your Lordship. They're now asking for pension and other benefits. And the single judge had referred to a writ petition, Your Lordship, an order of the writ petition, which has been now upheld by the Supreme Court, Your Lordship.
Then that can be which is that?
Yes, Your Lordship. That is SLA Civil Appeal number 7121.
Just write down.
Yes, Your Lordship. I will write down.
Later. This appeal by the state and in functionaries seeks to call in question a Learned Single Judge's order dated 5/9/2022, whereby respondent employees WPC OAC number 2478 of 2017 having been favored, relief has been accorded to him or her.
Him, Your Lordship.
To him in terms of order dated 2012-2018 entered in WPC number 13852 of 2005. Between is not there about that case.
No, Your Lordship. This case was referred by the single judge that as per this case order.
This case itself went to Supreme Court.
Yes, Your Lordship.
Which had a matchable fact matrix. First up, we are told at the bar that the said in the said WP, a direction has been issued to the authority to reckon pre-regularization service as well for the purpose of determining the qualifying service for terminal benefits. First one.
Next paragraph. Having heard learned counsel for the appellants, AGA, learned AGA for the appellant, and having perused the appeal papers, we decline indulgence in the matter inasmuch as the appeal has been filed with the enormous delay of 711 days with the first 11 days. Though an application in IA number 174/2024 supported by an affidavit has been filed explaining the delays of 463 days, the other part of the long delay remains unexplained. First off, even otherwise, the explanation offered is not logical. First off, the sages of law have said that the law relating to limitation is a statute of peace and repose. And therefore, courts do not come to the aid of sleepy and tardy. First, next paragraph. The other ground as to why we decline indulgence in the matter is that the impugned order has been structured in terms of a coordinate, another learned single judge's order. Go to that.
This is a division bench, Your Lordship.
That also.
Yes, Your Lordship. But the then Chief Justice.
You are right. In terms of a coordinate bench's order dated 2012-2018 entered in a similar case, that is WPC number 13852 of 2005. First off, the said decision having been challenged, the said order was challenged by the appellants herein before the apex court in SLP number so which came to the negative on
9/9/2021.
9/9/2025. 21. First time. However, the present WP was filed way back in 2017. First time. Therefore, the order of the learned single judge becomes unassailable. First time. Next paragraph. In the above circumstances, appeal being devoid of merits is dismissed, is rejected in limine with a direction to the appellants to implement the impugned order of the learned single judge within an outer limit of 3 months. 3 months. Failing which, they run the risk of being held up for contempt. First one, a copy of this order shall be sent by speed post to the respondent employee immediately. Yes.
Item 2.
Item 2, Your Lordship, is also a state appeal, Your Lordship. This relates to the Saroj Chandra Padya case, analogous with Saroj Chandra Padya case, Your Lordship, which was placed 2 months after the learned Advocate General having requested Your Lordships for granting us some time, Your Lordship.
It should be adjourned.
To that same.
Not along with other matters.
Yes, Your Lordship. Do this. Hemant Chopra.
Call this matter
2 months after.
2 months after.
after 2 months.
Yes.
In as much as challenge. The other bench is hearing that.
No, Your Lordship.
Apex court.
No, Your Lordship. Your Lordship is hearing.
We have fixed that.
Yes, yes.
Give that number. We'll call along with. We'll say that. Call this matter along with the.
197 WPC 197.
You are right.
2024.
97 of
24.
2020. Yes.
Item 3.
Item 3, Your Lordship, is again a state appeal, Your Lordship.
But in what we doing is, sister, we can issue notice in this
Yes, Your Lordship.
so that
Like that,
Yeah.
others will enter there.
Yes.
issue emergent notice both on main matter and delay application. But what is this 1044 days?
Your Lordship, those are all related matters. They're in hundreds, Your Lordship. They've been filed in hundreds.
Returnable within 2 weeks. First, call this matter along with so and so. Okay.
Item 3.
Item 3 is also a state appeal, Your Lordship. This is regarding regularization of the services of the petitioner who initially had joined as a sweeper cum watchman, Your Lordship,
Sweeper come watchman.
in the year 1998.
Why you trouble them?
And the single bench has said that since he has given service of more than 22 years, you regularize him as per Uma Devi's case, Your Lordship.
Even according to Uma Devi, they said Uma Devi may not be that like.
Yes, Your Lordship, because he is not on a regular appointment.
Now because of Jago and
Yes,
other
yes.
things, take note.
Bholanath and Pavan Kumar also, Your Lordship.
Jago has become a mixed sign for the.
Now, my lord,
Now Bholanath and then Pavan Singh.
great cannot pursue.
Pavan Kumar.
First paragraph C. Only the WPC number, WPC OAC number 1261 of 2017, having been favored. A direction has been issued to the appellant hearer to consider the case of respondent employee for regularization in the light of Secretary State of Karnataka versus Uma Devi, 2006 4ACC 1, within a period of 4 months, and also to grant consequential service benefits as admissible. First up. Next paragraph. Learned AGA appearing for the appellant. One more sentence. The appeal is moved after booking a long delay of 723 days and an application in IA number 6840 of 2024, supported by an affidavit accompanies the appeal memo. First up. Next paragraph. Learned AGA appearing for the appellant vehemently argues that the decision relied upon by the learned single judge, namely Uma Devi Supra, instead of supporting the case of respondent employee, supports that of the appellants, and therefore there is an error apparent on the face of the record warranting interference of this court. First, next paragraph. Having heard learned AGA for the appellants and having perused the appeal papers, we decline indulgence in the matter for the following reasons. 1. Firstly, the appeal is filed after booking a long delay of 723 days. First time. The explanation offered in the application along with affidavit does not constitute a sufficient ground, sufficient cause for the condonation of delay. First time, merely because appellants are the state and its functionaries, the law of limitation does not differ. First time, why state should be shown a greater leniency is also another aspect. First off, therefore, the application for so the subject application is liable to be rejected. First one. Next one. The second contention, the contention of learned AGA that the ratio in Uma Devi, instead of supporting case of the employee, adumbrates that of the appellant, may not be much examined, in as much as the law relating to regularization of services has marched from April to May and now to the June of its life, pursuant to Jago, then other two which are Shripad
And Dharam Singh.
and Dharam Singh. First time. The view of the apex court, the view in Uma Devi to a great extent loosened. First time. The said decision has been considered by the apex court in Jago. He considered in Jago. And only thereafter, certain principles have been laid down in the matter of regularization of services. First, admittedly, the appellant gained entry to service when, madam?
Entry to service in the year 1998, Your Lordship.
Way back in the year 1998. First off.
1899.
With effect from 1/8/1998. 98. Right? 97. 1/8/1997. First off. At this long comma, denying regularization would be denying justice to her or him.
Him, Your Lordship.
Justice to him, which a constitutional court cannot afford to do. First one. Next one. In the above circumstances, same. The other one, instead of 3 months, make it 8 weeks.
Item 4.
Yeah.
Item 4 is a state appeal, Your Lordship. This also relates to that Sarath Chandra Parira's case, Your Lordship. After 2 months.
Issue emergent notice, returnable within 2 weeks, along with WP.
Oh, bless you.
Next.
Item 5.
Item 5 is a state appeal, my lord.
Yeah.
Here challenging the order of the single judge, my lord, who has directed to
OCS pension rules.
OCS pension rules because appointment.
Not by judgment.
No, my lord. Here it's a case. My lord. It's a case where the advertisement was made for junior clerks in the year 1995.
Give the date.
It was. Date is not there. 1995. For junior clerks, my lord. Thereafter, my lord, the merit list was published of 79 candidates on 7/1/2000.
79 candidates.
My lord. In between, my lord, 7/1/2000 till 36.
Merit list is dated
7/1/2000. My lord. This petitioners was serial number 2 of SC female category.
SC, scheduled caste.
Scheduled caste. female category,
SC female.
my lord.
Serial number
2,
in the list.
my lord. On 7/12/2006, the government extended the validity of the merit list from 7/1/2000 till 30/6/2007.
GO dated
7/12.
7/12/2006.
2006.
Yes.
Extending it from 7/1/2002.
7/1/2000 till 30/6/2007. After complying the relaxation provision under OMC rules 1985.
7/1
2000 till
2000.
30th of June 2007.
Yes.
wide order dated.
It is not there, my lord. Department wide letter dated 7/12/2006. In order to fill up 60 number of posts of junior clerks in the Sundargarh district.
This was from which district?
From Sundargarh. Huh?
Sundargarh.
From Sundargarh district.
Now, how this is relevant?
My lord, this is relevant because the petitioner joined in service on 9/3/2007.
Extended merit list,
My lord,
life of merit list.
was there 36/2007 within the validity of the merit list. She joined on 9/3/2007. My lord, now the question comes, my lord, whether can she claim pension
9/3/2007.
2007. The advertisement was made in the year 95. She joined on 9/3/2007. My lord, now the question comes whether the can she come within the 1992 pension rules?
Which got abolished in
My lord, in reply to that, I am referring to Rule 9 of the pension rule, sub-rule 4.
Rule 9 of pension rules, 1992. 90.
Yes, 92.
92.
Yes.
What they say?
He said, my lord, sub-rule 4, notwithstanding anything.
Sub-rule 4 of?
Rule
1992.
Sub-rule 4 of Rule 4.
Rule 3. Rule 3. Rule 3. Rule 3, sub-rule 4.
What does it say?
It says, my lord, notwithstanding anything contained in these rules, all persons appointed under the government of Odisha with effect from the first day of January 2005 shall not be eligible for pension as defined under sub-rule 1 of Rule 3 of the said rule, but shall be covered by the defined contribution pension scheme as specified below. This meant the candidates, those who were joined after 1/1/2005, they will not come under the pension rule as specified in Rule 1, sub-rule 1 of the Rule 3. Because of the fact that this petitioner was joined in the year 9/3/2007, she will not be covered under Rule 3 and Rule 3(1). She will come under NPS, new pension scheme. But the court says, Honorable Single Judge says to release all the pensionary benefits accordingly, while court allowing the prayer made in the writ petition, direct the opposite parties to extend the benefit coverage under OCS pension.
To others, what you have done?
My lord,
To others like him, what you have done?
my lord, those who were appointed prior to 2005, 1/1/2005.
Covered by, there is no argument
My
on
lord.
that. In these, those who have been appointed post 1/1/2005,
My lord,
are there cases where you have granted the pension?
probably at that instruction I.
What is your answer?
My lord,
Granted.
my granted.
To whom they have granted?
My lord, that is in the judgment, your lordship. Lord, single judge has dealt that matter.
You can't be discriminatory in that way.
No.
Then that cut-off date becomes meaningless.
My lord.
They have to come, first they have to come under the rules, then the benefit will be extended.
That's true.
The rule says this.
But correct. But that rule is loosened by your own conduct because you did not adhere to the prescribed date, 1/1/2005.
My lord.
You can't be lovely to a section of people and you cannot exhibit hatred to other section.
No, I think.
No, Learned Single Judge, where have you stated in your appeal memo? What Learned Single Judge has said that others have been granted pension is not true. Where have you stated? Show that.
My lord, similarly matters 9, 10 and 11 is there,
Yeah.
which is allotted to me.
No.
What has happened, similar, the learned single judge has relied on a judgment of tribunal and said that they are covered under that judgment. That is not correct. Why that is not correct, my lords? In that judgment tribunal, the person secured less number has been given appointment earlier to 1/1/2005.
Where is that? Where have you taken up?
My lords.
Where have you taken up that?
My lords. My lords, page 6.
Page 22.
In our writ appeal, this is item number 9. Page 6.
So it's fine. You don't know. And this is just
D, my lords, page 5D. May I submit, my lords? And it was disposed of at the first instance without notice to us. We distinguish this case.
But when the appellant was appointed, respondent was appointed,
My lord, in the year 2007. That is in
we
9/3/2007.
2007.
we have said 1/9/2005.
That is admitted. 9/3/2007.
The notification was extended up to 1/9/2005.
Yes. 2007.
Seven.
Extended.
Seven.
Then the one
Is it true? 1/9/2007.
No, no.
Seven.
My pension scheme. Not this one.
No. Pension scheme was not. That is 1/1/2005.
1/1/2005 scheme was notified in September 2005.
Yes.
Is it not?
No.
So any appointment up to September
Yes, my
2005
lord.
has been covered.
There were some judgments in that light.
Yes.
Yes.
In this case, as you say, others have also been covered.
Minor.
Have they come after 9/2005?
1/9/2005.
My lord, that is, in the case of your lordship, I have brought that. One in case of that, the ratio has been decided in case of Anand Chandra Das,
No,
which has been
no.
confirmed by the Honorable Apex Court.
No, that is not your view.
My lord, in this case, your lordship, also from the same list, your lordship, from the same.
Anandas
Well-
joined before 1/9/2005.
My lord, that is, your lordship.
Because of the notification, it was decided that.
Issue is your lordship when advertisement was made.
Ashok Swai versus
That
State of
was
Odisha.
time.
Ashok
That-
Swai versus State of
My lord. I have seen that.
That you see.
Covered by that says that.
From 1/1/2009.
Yes.
The 5. That is why.
Retrospective, those who had joined up to September 2009, 5, they have been allowed. Even in our day for this.
Yes, I remember that. Yeah. but he was appointed subsequently.
In my case, Your Lordship, 907 days is delay. That is first preliminary and technical ground. Then second point, Your Lordship, from the same list, Your Lordship, where I stand, others, they have been extended the benefit. And
Sure.
that has been relied,
Show that.
my Lord, that is, Your Lordship, in the impugned order, which has been challenged.
Whether they were appointed after 1/9/2005.
My Lord, that is
My lords, they were given appointed, but their case was different. Why, my lords? In the select list, some persons placed junior to him, less than below them, were given appointment. That is why the learned tribunal held that you cannot do that. They will be given benefit from the date.
Prospective period.
Yes, that his other persons.
Because they were denied,
My lord.
even though they were
Exactly.
entitled to be appointed before 1/9.
Exactly. That was not considered by the learned single judge.
My Lord, not all. That is some of. In my case, Your Lordship, counter, that is, case was not disposed of at the time of admission. Notice was issued, counter was filed.
Now you show that.
My Lord.
There is a rule which prescribes the date, cutoff date.
My Lord.
That was 1/1/2005. That came to be extended to 1/9/2005.
My Lord. I
You
follow.
show
My Lord.
any employee appointed after 1/9/2005
My Lord.
he is given the pension. We'll give you right now.
But then I have to take instruction because Your Lordship, this is first time for admission.
Okay.
And also notice has not been issued. I so much entered appearance.
You pay that how many days delay?
907 days.
907 means how much? 20
That
rupees.
is
How much it will be? 18,000 plus
18,000.
1800.
18,000.
18,000.
It is 20 rupees per day. They are all poor people. They can't fight the litigation. We are just thinking of.
they are not poor, my lord.
Huh?
They are all clerks, my lord.
What? Why they should suffer? This appeal is filed after bringing a long delay of 907 days. First up, an application supported by an affidavit accompanies the appeal memo seeking condonation of delay. First, learned counsel appearing for the respondent employee opposes the application. First, next person, having heard learned AGA for the appellants and learned counsel representing the respondent. We have heard learned counsel, so it's so and so. First, a very important question touching the exchequer of the state, e-capital, is involved in the matter. First of all, that is as to whether the persons appointed post 1/9/2005 are entitled to be covered under sub-rule 4 of rule 3
Yes.
of the Odisha pension rules 1990.
Orissa
Civil
Service
within bracket pension rules
1992.
1990. First one. No prejudice should be caused to anyone if application is allowed and delay is condoned on terms. First one. Not condoning delay may result into laying down a wrong precedent, arguably wrong precedent that may hurt the purse of the state. First, thus there is a merit in the main matter as well. First, next one, in the above circumstances, the application is allowed and delay is condoned, subject to appellants paying, appellant state paying the respondent a sum of rupees 9,000. How many days delay?
907, 907.
9,140 rupees. Into brackets, rupees 20 per unit. Bracket company. Within 2 weeks, failing which the application shall be deemed to have been dismissed, and as a consequence, the appeal as well. First, call this matter after 2 months.
Item 6.
No, in 6, how many days delay?
In 6, it is 913 days.
913 will be 10 rupees minus. That is 160. 19,160. 908 days delay. First one. In second one,
appeal provision.
913 days. 18,260.
In this case,
My lords, in these cases, notice.
Notice issue emergent. Issue emergent notice. If the appellant's deposit rupees 10,000 in the registry within 2 weeks as a precondition for considering the delay application, failing which the application stands rejected and as a consequence appeal on.
let it be some more time maybe
All,
given
4
because
4
weeks.
limited. That's the only way. Now the best way is to rob the exchequer. That is the best way to threaten these people. Yes.
Ultimately, our money.
That's one. That's one. Yes. 7 also. Same order. Yes.
Item 8.
Same up to 11, my lords.
8, 9, 10, 11.
Item 12.
Follow on these matters. Here, from 6 to 11. Follow along. Yes. We'll give you 3 weeks, not 4 weeks, brother. Because we have already treated the matter. That may be to your advantage, to the advantage of others also. Up to 3 weeks. Within 3 weeks. Call immediately after 3 weeks. Call. Next.
Item 12.
My lords, item 12, impugned order at page 30. My lords, relying on the judgment passed in other cases, this case was disposed of.
Correct. What happened to that other?
It was set aside in appeal, my lords.
Set aside. These orders are set aside.
My lords.
Issue emergent notice. How many days delay?
This
1,043. You will deposit 25,000 rupees in the register.
My lord, it will be discrimination.
No.
20 rupees, it comes 20,000.
20,000, no brother. 20,000.
1,095 days.
1,095 days. 1,095 days. How much it is? 1,000 will be 20,000. 3,000. Where?
How you are saying?
3090. 23,500. Okay. Got the point? How you read that statement? Issue emergent notice. If appellants deposit a sum of rupees 20,500 with the registry within 2 weeks.
3 weeks, my lord.
3 weeks. 3 weeks. as a precondition for consideration of the delay application, failing which the application stands rejected and as a consequence appeal as well. Yes.
Item 13.
Let it come on some other date.
Already decided.
Yes, it is decided, but I am to place that. How
I have retired since I have retired since.
How
2 weeks at the request of
we have the 70 rule.
Only prayer, my lord. I have retired from service since 30th September 2024. Till that they are not releasing my pension.
Within 2 weeks we'll take that.
Fixed date, my lord. Delay of more than 1,000 date.
Complete. Brother, you have to deposit how much money?
More than 1,000.
Eh?
1043.
104.
Issue notice. Will condone delay.
No, but I had the matter because I'm already covered and the government.
Delay. You will get money. You don't want money also.
The man not getting pension, that is your problem.
So you get money.
No, he is getting pension, but
Provisional pension only.
But this money, as a condition, you have to pay 20 rupees per day.
yes.
Like from next month, it will be 30 rupees. So what happens? You have to file it in this month.
Budget in March.
What to do? Yes. Issue notice, learned counsel Shri so accepts notice for the respondent employee. First, there is a delay of 1,043 days in preferring the appeal. First, learned counsel for the respondent opposes the application. For application in INR so supported by affidavit for condonation of delay, saying that it is too long and that there is no plausible explanation. First, next one. Having heard learned counsel for the parties and having perused the appeal papers, we are of the considered view that throwing out the main matter only on the ground of delay would not do justice to anyone. Seven, there are some arguable points in the matter.
Then this matter already decided, my lord. Similar matter. Already decided.
Therefore, application needs to be favorably considered. First, next, in the above circumstances, application is allowed and delay is condoned, subject to the condition that the appellant shall pay rupees so and so, collectively pay rupees so and so to the respondent employee within 3 weeks, failing which the application shall be deemed to be rejected, deemed to have been rejected, and as a consequence, appeal as well. First up, call immediately after 3 weeks. Yes.
Item 14.
It's a state appeal.
This will not interfere. 1,539. Otherwise, you deposit 1 lakh rupees, we may consider.
This is in respect of regularization. Regularization.
How many years of service?
This is, it starts, the person I joined in 2012,
2012. Sixteen to 2000, not 2012, brother.
As contractual, he has been working since 2000.
Since 2000, not 2012. Kindly
22/9. 2000 was engaged in 44 basis.
All that service to be counted, na? Because of Thangabalu. You can't say that you will not count the contract service.
Then as per the orders of your lordships in today's list in serial number 3.
Same order.
Because after these 2 judgment,
You
I have
no
nothing
case
to
at all.
canvass.
the subject matter, the state and its functionaries are in this court appeal to call in question a learned single judge's order dated
9/6/2021,
whereby respondent employees WPC number 13787 of 2021 having been favored in the light of Uma Devi and ML Kesari, a direction has been issued for regularizing his services, his or hers. We can't make out gender in your state because his services.
His.
First one. We, having heard learned counsel, learned AGA for the appellants and having perused the appeal papers, we decline indulgence in the matter. Mainly because the appeal is preferred after brooking a long delay of 1043 days. Offering a legal explanation in the application in IA number 1438 of 2025 supported by an affidavit.
This is item 14, no?
This is item 14.
14.
So 15.
1539. 1539.
1539.
First off. It will be how many years? 1539 will be. 1539 divided by 360.
Alert judgment is of 2021. It is in around near about 4 years.
4 years.
More than 3 years.
More than 3
4
years.
years.
More than 4 years.
First off. Why all these more than 4 years the state was sleeping is astounding. Astounding. First, such a long delay cannot be condoned merely because the applicants are state and its functionaries. First one. Next paragraph. The above apart, the respondent was engaged in
16/10/2000.
with effect from 16/10/2000. First time. Therefore, learned single judge rightly applied the decision of Apex Court in ML Kesari. First time. Now, because of further march of law, why the Jago and Shripad, with Jago, Shripad and Dharam Singh, the case of the appellants becomes still weaker. Still. First one. Next one. In the above circumstances, appeal being devoid of merits and there being no explanation for the plausible explanation for delay, both the application and the appeal are rejected in limine. Appellants are directed to give effect to implement the impugned order of the learned single judge within 3 months and report compliance to the Registrar General of this court within 3 weeks. Here it is within 3 weeks. Failing which, the concerned officials run the risk of contempt proceedings.
Item 15.
Registry to send copy of this order to the respondent is field post.
Item 15.
15 Miller.
Yes.
There is a delay of 589.
What is the matter?
Challenging the judgment.
Huh?
Challenging the judgment dated 1/3/2024. only on the ground that the screening committee has approved because it is a premature retirement, compulsory retirement.
Review of service.
Review of service.
Directed for reinstatement.
Yes.
What the reasoning of the learned single judge?
Because of this, they are not taking into consideration this screening committee review decision.
How many
And
years of service he has put in?
Service is, my lord,
It must be, he must be above 50 years.
above 50.
So, what is the
That is
length
the
of
cut.
service? Length of service. Any adverse remark in the service record?
Because of the ill health continuously remain absent. And
How
then
many years? Therefore, we are asking you, how many years he has served?
service
Sometimes bacteria, virus trouble the man for very long period. During his youth, he served the state throughout. Merely because he has got some ailment, if you throw him out, where he should go?
review in the particular district.
Sorry,
Is in 87.
how many years of service he has?
87.
1987.
Yes.
When the screening took place?
Screening took place in 2020.
2020.
2020.
How many years?
212.
Huh?
Services for
97, 2007, 2017, then 3 years, 33 years.
33.
What kind of, who are these screening people? After 33 years, what will remain in the man's blood, bone and flesh? 33 years he has served the state. No. Take them. You should be kind. The employer should be kind. He should not act like a butcher. If for a person who has served for 33 years, if he is sent home by compulsory retirement, what he will think about the government? Government would be the first enemy of the citizen in his views. He will go on campaigning the same wherever he goes. No, that will not augur. He may campaign against us also if we uphold us. Take them. The state and its officials are in intra-court appeal for laying a challenge to a learned single judge's order dated 1/3/2024, whereby respondent employees WPC number 11221 of 2021 having been favored, his compulsory retirement has been struck off with a direction to reinstate him service with all consequential benefits. First off, appeal has been filed after booking a delay of how many days? 589 days. And an application in I number 4334 of 2025, supported by an affidavit accompanies the appeal memo. First off, having heard learned AGA for the appellant and having perused the appeal papers along with the application, we decline indulgence in the matter for the following reasons. Number one, firstly, kindly be seated. Firstly, the appeal has been filed after booking a long delay of 589 days, and the explanation offered in the application supported by affidavit is not plausible at all. First, merely because appellants are the state and its entities, the law of limitation cannot be different. First, what applies to goose equally applies to gander. First, any argument to the contrary would militate against the principle of equality, parity, and justice. First, therefore, the application is liable to be rejected. Next point. We also notice that the respondent employee has put in a long and spotless service of 33 years.
1992. 1/6/1992.
30 years. 30 years. First off, what would remain in the blood, the bone and flesh of such an employee after putting in such a long period, needs to be understood with human heart, provided the heart is at the right place. First off. However, those who took a decision to dispense with the services of respondent appear to have heart, but at a wrong place. First, our constitution ordains that the state and its instrumentalities under Article 12 have to conduct themselves as model employers. By the Bhupendranath Hazarika versus State of Assam, 2013 is so and so. First time. Otherwise, what Jeremy Bentham asked would become true into inverse. What is state without justice, but a band of robbers? Inverse complete. But the impugned order has brought about a just result in the fitness of things. First one. Next one. In the above circumstances, this appeal being unworthy of merits, both on it, unworthy of consideration, both on intrinsic merits and on delay application, is liable to be rejected, and accordingly it is rejected in limine, and accordingly it is. First one, registry to send a copy of this. The appellant shall implement the impugned order of the learned single judge within an outer limit of 3 months, and report compliance to the Registrar General of this court within an outer limit of 3 months, failing which the officials run to the risk of contempt proceedings. First of registry to send. Yes. Brother Mohanty, we are all mortals. A person who puts in 3 decades of spotless service, if he is unceremoniously sent only on the ground that the screening committee has said, but at least 1 black mark is necessary in the service register. 1 mark for every 5 years. For 30 years, 6 marks are necessary. We have held one such, we have taken that view, and the Apex Court affirmed it.
Apart from that, my lord, since a peon in a school, Group D employee, we have no words, my lord, because we are simply discharging the duty. We cannot say more, my lord.
Above upon the respondent was not the deputy commissioner, he was only a peon. First off,
Group D.
that is a Group D employee. First off, such persons need protection of the writ court when harsh treatment is meted out by the state, as has happened in this case. First off, therefore, from any count, order of the learned single judge cannot be faulted. Just structure.
Item 16.
Our
Items.
our steno is very good. This person, really, I have seen his.
He is one of the experienced steno also.
I'm very committed.
We know him personally.
Very committed. I have seen his draft. He will repair our own draft. Yes.
Item 16. It is as good as item 14, my lord.
14.
Only so far this delay brokerage is 712. Other things are remaining time. Karnataka and
Regularization.
yes,
30 years complete.
How many years of service?
30 years, my lord. From 1996.
1996.
Whether learned single judge are referred to Uma Devi?
My lord.
Yes.
my lord.
It is at page 23.
Kesari also.
My
Page
lord.
23.
Right. This intra-court appeal by the state and its functionaries seeks to assail tailor-made single judge's order dated 1/12/2023, whereby respondents WPC number 23518 of 2023. Kindly be seated, Asanto. Having been favored.
Miller, 3351.
33518 of 2023, having then 1/11/2023 order. Having been favored, a direction has been issued for the regularization of his service within a period and to grant all consequential benefits in accordance with law within a period of 3 months. First one. Next paragraph. Having heard learned counsel, the appeal is moved after booking a delay of so many days. Yes. And an application is based on science. Next one. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. Number one, the intra-court appeal is moved by the state after booking a long delay of so many days. First one, although an application in I number so and so supported by affidavit is filed, the explanation offered for the delay is frugal and unacceptable. First answer. Therefore, the first one, there cannot be a different yardstick for the state and its officials for when it comes to the limitation period. Of course, subject to all just exceptions. First, therefore, the application is thoroughly unworthy of consideration, lenient consideration. First, next paragraph. The above apart, learned single judge, while granting relief of regularization, has considered the apex court decision in Uma Devi
And ML.
and ML case. Yes. In as much as the respondent has put in a service of about more than 3 decades. More than 3 decades.
3 decades.
Come on. The entry date being 1/1/1996. 96. First, what is this designation?
Class 4. DLR.
That's
Class 4 DLR. Class 4 DLR.
DLR means
Delhi level.
that apart. The respondent is a member of last rung of the ladder of service. First number. Such a class 4 employee, if denied relief, the judicial process at the hands of constitutional courts would lose meaning. First one. Next paragraph. In the above circumstances, rejecting science within as it is. Next.
Item 17.
This is an appeal by the state involving delay of 476 days, my lord.
712 days.
My lord? No.
Yes, it's indicated.
It is indicated 476 days.
You are right.
My lord. My lord, my humble submission before Lordship kindly.
How is your health now?
No, not health issue. That was a Shraddha of my father's annuals. My lord, page 16, the paragraph number 5, that is the direction issued by the Honorable Single Judge, where Honorable Single Judge directs the state respondent, state opposite parties to do well to regularize her service as per the rules. My lord, this is an innocuous order. Listen, in no course order. Without recording my concession, below.
You,
Para 3.
you should thank him. Covered by that Ajay Kumar Behera.
No, Ajay Kumar Behera is also not standing on the way. That is also in the light of as per rules. So as per rules, my lord, we'll go to the rules and straightway deal with the matter as per rules. That is rule 2013 rules. That is also annexed at page 45. Your lordship,
What is that?
page 45. My lord,
Come in the.
page 45 is the rule.
In the light of that, you have to consider
Yes, we will also.
that part. That's only
That's
that.
Well, the case of the respondent is not regularization, antedation of the date of regularization.
That's what.
The respondent have already regularized.
He was regularized on which date?
That is, the writ petition, I have not received any copy, my lord.
He is Group D employee.
Yes.
No, my lord.
No,
No,
group
my lord.
C.
Huh?
Group C, my lord.
Group C, staff nurse.
Staff not. The order of regularization was issued, my lord, in 2021, but with effect from 2014, my lord.
The regulation order is dated
17/4/2021. 7/4, my lord. 7/4/2021.
with retrospective effect from
2/8/2014.
when they entered service.
In 99, my lord. They should have
Date of service.
date of appointment, my lord. 29/12/99. 1999. Joined, my lord.
Why? On what basis you wanted antedating?
And on completion, since they were initially appointed on contractual basis, on completion of 6 years of service, they should have regularized, my lord. But instead of that, they have considered in case of Ajay Kumar, the basis on which this honorable court directed, it is a 2 division bench order.
Instead of after 6 years, they made a lot of delay.
Yes, ma'am. Until in 2014.
2014. That they have to antedate to 2005.
Six. 5 or 6.
5.
That is the limited prayer before the single judge.
29/12 it is. Mr. We will be you will be little worse off in this appeal. In the sense, the learned single judge has not granted the correct relief. We will
Yes.
make it correct now.
But they have not preferred any other.
No, it's all right. Therefore, we said,
Yes.
you will be worse off in your appeal. Ordinarily, an appellant will not be worse off in his appeal. At the most, he can say, I will go home as it is, dismiss it. But here, we will not do that. Here is a case where we have to modify, slightly trim
No,
the
your
order of the
Lordship may
learned
kindly
single
appreciate.
in their favor.
Your Lordship may kindly appreciate if at all he was aggrieved, she was aggrieved. See, it was open for them to challenge the order.
They have not.
They have not done.
Now we give that reason. Why that is not
No,
required to be
my lord,
challenged.
that will not be.
No, you can
My
challenge that.
Lordship, see that
There are
the
such
government
orders in the
has
apex.
given the opportunity to consider as per the rules. Now, Lordship may interpret the rule.
No.
Then I may be given the opportunity to go to the rule and submit.
Read.
Her case is
No, it's
not.
not. Read. Your rule. Read
Yes,
the rule.
antedated is not the misconceived prayer.
Otherwise, you will reject that application and again send him for
No,
litigation.
we will go strictly as per the rules mandated to the
show that.
That is page 46, 1. That is page 46.
Let us
Page
read
46 of the rule. Regular appointment. And your Lordship may see the sub-rule 2.
Conditions of service on regular appointment.
That is the rule.
Completion of 6 years of contractual service.
Yes.
See this. Or from the date of publication of the resolution, whichever is late.
Whichever
they
is
shall be
later.
Deemed to have been, no.
Whichever is
They shall
later.
be, correct, they shall be deemed to, later means not 25 years.
No.
Resolution
Later
is
means
the
on the date of resolution.
6 years.
Yes, 6 years.
Or from the date of resolution. When the date. of
Which
resolution.
that is the 17th September 2013.
Huh?
17th September 2013. 17/9/2013.
whether you have given the antedating to anybody else?
No, not antedated. It is to be only
Anybody they have given?
In Ajay Behra's case, pursuant to that order, they have complied all and extended all the benefits to the all paramedical staff.
All others you have
no.
given.
Yes,
But the rule says otherwise.
That's all right. But why did you give to others? Another set of people, merely because they work for your party, political party. You want
On
Eligibility.
Ajay Behra, whether implemented or not, I have to seek instruction. below.
No, he's saying we'll record. If it is not true, we'll review. We'll say immediately we'll allow the review.
Yes,
We can't.
that is that. Because that is the mandate of the Honorable Single Judge. That is the mandate of the order.
Of in this appeal. Yes, we justified by jurisprudential reason. There are such judgments that in every case they need not come to court in appeal. In
our appeal also, they will be.
In fact, order 41, rule 25 or 26. Exactly, I do not know. In CPC, 1976 amendment. New CPC. It says a defendant, a respondent who has not filed appeal can take up certain contentions to get more relief at the hands of the appellate court. Yes, that has been so interpreted by the apex court. At least there are two judgments. Order 41, rule 25, 26, something like that. It says that they can attack the grounds, findings in the appellate order. Apex court treated it. It went further and said they can seek little more relief at the hands of the appellate court. Rule 26, order 41, rule 26. That's what. Anybody can give that judgment, any youngster? Order 41, rule 26, where the apex court said, without filing appeal, a respondent can seek the relief in the appeal of the other side. Because we have been taught in the law school, an appellant cannot be worse off in his appeal, because it is his appeal. Therefore, he comes here for remedy, not for getting the injury worsened. On that principle,
No. We will simply abide by the Honorable Single Judge order.
I'm telling you why we do not agree with you. When we studied in the law school, that was our view. Our professor used to say, an appellant cannot be worse off in his own appeal. Suppose if a person goes to the clinic saying that I have got a small injury, doctor cannot do it bigger injury.
Because my argument was acquiescence. If it has been acquiesced by him, it has accepted by him, how can he seek the...
This is answered by the apex court.
Yes.
Right. To whom they have given regularization?
To the respondent.
Huh?
So far the others are concerned. That I have given the copy of the Ajay Behra judgment, my lord, division bench judgment.
All others, medical staff.
All paramedical staff.
Paramedical.
And it has been also admitted by the court, my lord, in running page 8 of the brief, their judgment is para 11, my lord. The second option question is whether the order which has already been implemented by the state government should be allowed to be changed or not. They have already complied with some of the order for which the decision was division bench has passed the order.
Second question is whether the order which has already been implemented by the state government should be allowed to be challenged. I think that's the thing. Yes, you have implemented the order.
That's why I'm saying that
13 February 2019, a number of the orders.
That's why I'm saying that that the order will prevail. Now we are going to implement this order also.
Means no, going by our version, we have an apprehension that we'll consider.
Yes.
We will meet all your.
Lordship observe whatever Lordship wants. But I only say that it's an innocuous order. We don't stand as a merit in the appeal.
This the state and its officials have filed this intra-court appeal, calling in question a learned single judge's order dated 9/7/2024, whereby respondent employees WPC number 15202 of 2024 having been favored relief has been conferred on him as under para 5. The appeal is moved after booking a delay of
476
days. This is a permanent paragraph in all state appeals. Only days will change. Yeah, and the sign is a sign. Next. Having heard the counsel for the parties and having perused the appeal papers, as also the delay application, we decline indulgence in the matter with some observations for the following reasons as under. First, next paragraph. Firstly, we do not propose to examine merits of the main matter in as much as delay has not been properly explained in the application in IA number 1867 of 2025 supported by 4583 of 2025 in respect of 476, not 5. First, in several such cases, we have held a view that the law relating to condonation of delay cannot be leniently construed merely because the applicants happen to be state and its entities. First, if the lawmaker wanted leniency, he would have made appropriate provision to that effect. First, therefore, the application itself is liable to be rejected for want of sufficient cause. First, next paragraph. The above being said, we also have undertaken deeper examination of the matter so that the true justice is done to the respondent employee, who is in the group C, being a male nurse,
Female,
female nurse,
nursing officer.
lady nurse. First, she was appointed on contract basis with effect from 29/12/1999. First, she secured a regularization order dated 7/4/2021, wherein the regularization was with effect from 2/8/2014. First, therefore, she had petitioned the learned single judge saying that it should be 6 years immediately after. It should be immediately after 6 years of joining date, as has been provided in rule. Which rule, Mr. Panda, you said?
2013 rules, that is.
In terms of rule, which rule you said?
That is resolution, my lord, 79/2013.
Resolution.
Resolution dated 17 September 2013.
The single judge are held like that, not held like that, my lord.
The learned single judge has rightly granted the relief to the effect that the appellant's regularization has to be with the retrospective effect. That is, with effect from the date she completed 6 years of service on contract basis. First up. Next paragraph. We are also impressed by the reasoning of the learned single judge, in as much as he has rightly chosen to follow a coordinate bench decision of this court in state of Odisha versus in WPC number 4099 of 2021 between State of Orissa versus Ajay Kumar Behera, disposed of on 20 April 2021, wherein paragraphs 12 and 13 read as under. That judgment. Right? I mark it with yellow. Yes. In the above circumstances, this appeal being devoid of merits is liable to be dismissed. And accordingly, it is. First off, the appellants to give effect to the order of the learned single judge and report compliance to the Registrar General of this court within an outer limit of 3 months.
My lord, may kindly consider that appointment order was issued on in 1999, but she joined
9/12/1999.
23/12/1999,
But she joined on 29/12.
23/12/99.
29/12/1999.
And
it's there.
but she joined in service as per her own representation 6/1/2000. That is at page 49. Your lord.
Make it instead of 22 days. Instead of 29/12, make it 6/1/2000.
6/1/2000.
My representation, I have stated that I joined on 29/12/1999.
No. It's see.
More representation I have added. That is typographical error, man. Not my knowledge, I'm saying that is my representation in the writ petition also, I have stated that I joined on 29/12/1999.
29/12/1999.
In the second case, my lord, Smita Panda case,
In fact, there are three matters.
We are coming.
and the order is 11/7.
Yes. What's
So Smita Panda case from the
That date also.
all three.
All three are similar, mine.
But
order dated
other two and so.
I will inform the
Essentially similar to the one in WPC in writ appeal number 1867 of 2025, wherein appeal has been dismissed, state appeal has been dismissed. First, similar matters have to be treated similarly. First,
only the order date is different.
above circumstances, these appeals are also liable to be rejected, and accordingly they are. Okay. In order of the implemented within 3 months, and complaints to be reported. Same in all those cases. Yes.
Item 18.
Item 8. The appeal by the state involving delay of 467 days.
What is on merits?
It's that regularization of service and all pensionary benefits.
How many years? 11/3/2001. No.
11 days.
Huh?
There is a break of service of 11 days. That 11 days has been condoned.
4/5/1974. Cleaner with effect from
74.
4/5/1974.
My lord.
How many years of service?
My lord, he retired from service on, my lord, 11/3/2001. It's a Group D post, my lord. There is a gap of 11 days.
1 second. Retired on
11/3/2001. By virtue of voluntary retirement scheme, my lord.
VRS.
No.
How much qualifying service? How many days required? How many years of service required?
My lord, in fact, my lord, he was initially appointed as cleaner.
You are not asking.
My lord, qualifying service, my lord, 20 years, my lord. But the thing is that, my lord, only thing, my lord, there is a gap of 11 days. That 11 days has been condoned by the London single judge.
Where is the power?
My lord,
Where is the power to condone? It's a qualifying service. Suppose the suit is for 3 years. If the suit is filed on 366 days, can the judge condone? If 11 days for you, tomorrow another person says 13 days. Later another person says 15 days. If you have done it 13 days, why not 15?
By virtue of my lord one
Where is the
notification.
power? Where is the power? Show that. If there is power, we will let go.
My lord, that lordship kindly have a glance
It will have far-reaching consequences because we will be laying down a very dangerous precedent. Because it's a matter of policy that people should have put in so many years of service, which would be qualifying service. If the state has got that power, you show that we agree. That power learned single judge may also exercise sometimes. Which is that section?
My lord, since it has come up for
47, Rule 47 of the Orissa Pension Rules.
Provision is there for condoning.
No, not condone. Only the qualifying period of service.
But I read in one rule which said the government can relax any of these rules. There is such a rule.
There is a clause in 32.
32. In general rules relating to general recruitment.
They have moved for the same in that police case, my lord.
That's what you had argued that.
But there was a clause.
My lord, in fact, my lord qualifies that 20 years, my lord, because he was appointed on, my lord, 4/5/1974 as a cleaner.
4/5/74 as
he
cleaner.
Retired on 11/3/2001.
On VRS.
Yes.
Then where is the condonation? Why that single judge condonation he says?
My lord, no, condonation is breakage of that service.
Break of service.
How many years of? How many days?
11 days.
11 days. Service means?
My lord, he was initially appointed as cleaner. Thereafter, my lord, there was a break of service. He was again, after 11 days, he was again appointed as
artificial break.
SS Vishweshwaraya was
artificial breakup.
No, that is not.
That has been overruled. That has been
absolutely. There is one Dr. SS Vishweshwaraya, Professor SS Vishweshwaraya versus Karnataka University. Covered. Then. Right now.
This is 23rd April 1974 to 3/5/1974.
There is only 11 days gap between unemployment to another. Right. Sit down. The first paragraph whereby whereby respondent employees WP number so and so having been favored, relief has been accorded to him by him as under. Go to that. You just see it there. Appeal having been filed with delay, an application is considered. Next paragraph. First paragraph, delay is with this one. Second paragraph. The respondent employee had joined the service on 4/5/1974 as a cleaner. First one. Thereafter, he left that service and came to be appointed as?
My lord, same cleaner, my lord.
Again as cleaner. With a gap of?
11 days, my lord.
Gap of 11 days.
Para 14.6 of the judgment is
correct. 14.6 and 15.
Yes.
First. For qualifying service, what is required is a minimum of 10 years. Under the pension rules.
20 years.
20 years.
20 years.
20 years.
20 years. Under the provisions of Odisha Civil Service Pension Rules 1992.
42. Rule 42.
In terms of Rule 42. First time. If the break in service is not condoned, comma, the appellant, the respondent would have been deprived of the terminal benefits.
20 years.
First, this aspect having been looked into by the learned single judge, comma, he has rightly condoned the said in as much as the total length of service exceeds the qualifying service. First, Rule 42 reads as under. Only 42(1). And the respondent retired on 11/3/2001, his VRS application having been accepted. First, learned single judge at paragraph 14.6 has observed as under. Below that, we are in full agreement with the same. Next one, in the above circumstances, appeal is rejected. Registry, the 3 months, compliance within 3 months, reporting to the registrar. He appears for the court. Yes.
In fact, it is partly complied, my lord.
It is also complied with them.
Partly complied, but now they challenge this.
Next one.
Item 19.
19.
Item 19, my lord, the similar matter your lordship have kept 2 months after that is along with WA number 197 by 2024.
The 2 weeks.
State versus Hemanta Chotra.
WA number
197 by 2024. 2020. State versus Hemanta Chotra.
All right. How many days delay?
That is
617 days. Deposit the money. Issue emergent notice, both on claim matter and the application. If the appellants collectively deposit a sum of rupees, how much it will be? 600 means 12,000, no, 12,340 with the registry within 3 weeks.
3 days.
12,000, 340. 340 days in the registry.
Well, within
3 weeks.
no 3 weeks. Yes. Good.
Within 3 weeks. First half.
6,000 will come how much?
6,000. This is 12,340.
340.
40.
Good.
Through and 30. 340.
340. Yes.
Yeah.
Good.
Otherwise, appeal stands to it. Okay.
Well, the last matter, item 20, I am not having the full brief. Maybe called next week. Lord.
Is it? Let us see 1 second. We'll just see if we can issue notice. We'll issue. Otherwise, we'll give time to it.
I'm not having the appeal memo.
No, we are not damaging. But we may pass an order in your favor. Yeah. No, Mr. Panda,
My lord.
you take time because we are not impressed. We may dismiss your appeal.
Yes, yes.
Call immediately after 2 weeks at the request of the Okay. We'll come back.
Yes.
As this is after this list we are sitting, na?
Yes.
Or it is to that? No.
No.
After this.
Afterwards, sir.
You can come. Or can we come at 2? But so that we'll come with all these orders today.
Yes, yes, yes.
Contempt matters.
Huh?
Contempt matters only.
Yeah.
It can hardly take 15-20 minutes.
Oh, very well. We'll come back. Within 15 minutes they are coming back.
Like all the the list. But then in the evening when I got the final list, it was been deleted.
So many advocates are complaining like this. When memo is taken, they have to be posted. In fact, to the judicial registers. They should be posted. I don't like that because once lawyer, they will be under impression that their matters will come and they will answer their clients. Otherwise, what they answer, they have how to face the clients. No.
And in the meanwhile, contempt, I came to learn yesterday from the registry, the contempt has been entertained. So that review is pending, my lord.
Review is pending now.
Yes, sir.
But pending matters we cannot take now. Which contempt, which matter? Contempt before me.
Oh, yes, ma'am.
Let us wait. Which today?
No, it was to be listed today. I mean, the memo was allowed. It was there also, it was fed into the computer yesterday. Then when we got the final list in the evening, late in the evening, it has been deleted.
Okay. Next week, it can be taken.
Can it can. But if the lordship will be there on 6th, we got to
No, I will not be there. But other judges also will be there. Is that memo? Give that memo.
earliest possible. By.
Yes.
Well, on item number 1 to 7, all are fresh matter. Your lordship may grant some time for compliance with there and will come back with affidavit.
Wait. Note. Do you remember? Yeah. 1 to
7.
1 to 7. 7 to 11 also same.
The date may be fixed.
7 up to 11.
Please.
All police notice, okay?
Item 12.
Item 12. Is it post notice? Fresh one. Who pays for 12?
So Tushar Kanta Naik.
Go to that.
Fresh, your lordship, so notice.
Show me what he has said. In 12. You have done recovery even after interim order.
And your lordship, I have to ascertain, but that's it.
Same order. Well, all on 20th, 30th, 20th. Okay. Yeah. You show one order to me, then accordingly we think that, okay? Yes.
Item 13.
It's a fresh contempt.
First contempt is put off for compliance 8 weeks.
Well,
On which date 8 weeks? 23/9. Yes. Notice. Notice. Yes, next.
Item 14.
Originally 3 months
3
time
months.
was 3 months time was given.
1% interest.
1% interest. Notice that the order was duly communicated. That's valid.
Police notice. You will get that money plus 1% interest also. Yes.
15 also.
Item
Also same.
Same.
Smile.
Okay.
Item 16.
What is this matter, sister?
In 11/2025 has not been complied with. Press matter.
Next.
Item 17.
Press contempt.
Yes.
Item 18.
Item 18 also press contempt.
Yes.
Item 19.
The Honorable Court has not been complied. The Honorable Court has directed to visit the press contempt.
Yes.
First protest.
Yes.
Item 20.
Thank you, Lordships. Well, before I start, my lords, I just request your lordship to kindly consider this application sympathetically, lordships.
Right.
Because it's a case of regulation and the petitioners have put in 30 years of service. The lordship may kindly see.
30 years of service he has put in.
Yes, your lordships.
When he entered service on which date?
My lords, entered on service on 3/7/1996.
3796.
Yes, your lordships. Till today continuing, your lordships.
Without intervention of the court orders.
Well, initially I had filed an application in the year 2014.
2014, after 21 years, after 18 years.
Yes, your lordships. Thereafter, that matter was disposed of, directing the authorities to consider my case afresh, keeping in view the order of this honorable court.
That was WPC.
WPC number, your lordships. Let's hang on. 12240 of 2014, your lordships. Order is at page number 69, your lordships.
What it says?
Well, it's paragraph number 5, page number 69, your lordships. It appears that the said writ appeal, the order dated so and so passed in WPC number so and so Manoj Kumar Patra versus State of Odisha and Learned Single Judge has been confirmed by the division bench. Learned Single Judge by order dated so and so director opposite part number 225 to regularize the subject of the petitioner, which has been confirmed by the division bench of this honorable court. May I make one submission here, my lords?
1 second. This was disposed of on?
Well, this was disposed of on 15/3/2023, your lordships. 15/3/2023, my lords. Thereafter, I filed a representation and that was rejected by order dated 31/5/2023, your lordships, at Annexure 9 to my writ petition, your lordships.
That was rejected.
Yes, that was rejected by order under Annexure 19, 31/5/2023 to the writ application. Order at Annexure 19, order dated 31/5/2023, your lordships.
No sanctioned post. What are the grounds they have
Yes,
stated?
may I just pause your lordship for a moment? But each and every ground they have taken, your lordship have dealt with in the case in which I have filed in my IA, your lordships. Each and every same, the colleagues of the petitioner, same ground, your lordship. That is IA is there, your lordship. 2906/2026.
Do you have additional copy?
Additional copy, my copy, your lordship. Each and every ground. The same case, same colleague of the petitioner here, same department, same colleague of the petitioner. That is there in my eye. Each and every ground they have dealt with, your lordship have dealt with meticulously, lordships. Confirming the order of passage with Learned Single Judge.
But in this case, my lord, I have for opinion number 3, my lord. I have received the IA copy, my lord. I have to file objection in this case, my lord.
When notice was served on you?
The copy was.
I have the acknowledgement. 2 weeks ago I have sent. If the
We'll give 2 more weeks. Let him find the objections.
Right.
But otherwise, they will challenge it on the ground that opportunity was not given.
yes,
This one.
Why to run that risk?
no, your lordship.
Learned, you are here for whom?
But I am for the
No.
petitioner.
I have for opinion number 3, my lord. State Council for Technical Education and Vocational Training.
Learned, you are AGA?
No,
No, my lord.
Counsel, special counsel.
Mr. Dickey.
Senior advocate.
Mr. Das,
Yes, my associate.
you have to stand beside our son. Come.
Please,
Call this matter week after next. At the request of special counsel representing UP3.
Not to like.
Date,
Yeah.
the date may be fixed.
Yeah.
Item 21.
Yes, item 21. Just now I have been served with the objections to the, I need only 1 week time.
Next week?
1 week after.
Week after next.
Let's say analogous lots with matter. Second
Review
item.
petition has also been filed. My learned friend is appearing for the respondent in the review petition.
In the review petition.
Let's say I will file my power. Inshallah. Inshallah.
See, so it is here. Your name appears there.
No, Lord.
Has the instruction to appear.
You have inspection to appear.
He has the instruction.
Yes, see, so and so appears for. OP number? Okay.
OP number 1.
In review petition number 38 of 26.
Yes, Lord. 2 to 4 they have appeared. Notice noting is there. So for the OP number 1, I have been instructed to appear.
Any delay?
Yes, delay is there. As per noting.
That impleading application is also there.
Well, impleading application is also there. But in the original writ petition, well, I am the petitioner. Your Lordship disposed of that matter. That order has already been implemented and the managing committee has already been approved. They have challenged that order by filing another writ petition, which is pending before this honorable court. Well, that is, well, a WPC number.
Call this matter week after next at the request of learned advocates appearing for the OPs. OPs.
OP number 1.
Along with
That is WPC number.
it will come, you write down and give that.
Yes,
That is there in the assigned bench.
Oh, this is not with this bench.
Fixed to 9-3.
No, then
It has been assigned bench.
assigned bench,
to 9.
and it has been posted to 9.
then no, need not call this. But after that,
Only your Lordship may direct the petitioner to serve a copy of the review because they have not served.
if you ask, he himself will give 1 dozen copies to you.
No.
Give copy to him. He wants copy. Huh?
Then a review. He is not appearing for the review.
Review is not there.
And I am.
The review, Mr. Panigrai is appearing. Who is he?
Mr. Panigrai.
Panigrai.
Issue notice. Mr. Panigrai, learned counsel is requested to accept notice for OP number
1.
1. OP number 1. Okay. I wish all happy Holi to everybody.
Same to Lordship.
Come out with flying colors.